All right. 234150 is called the State of Texas versus IFA. That's you, Mr. Sir. And you're here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that September 3rd, 2020, in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes. We did that.
Yes, sir.
Are you with me?
I'm with you. I'm good.
An agreement's been reached here where you would be pleading guilty and here, I'm gonna put it in a numerical, and I can't read
Look at
that you placed in that box. You would be placed in deferred or unadjudicated probation, fined $1,000, up to 10 years on probation, and there would be terms and conditions of probation which are normal and customary, and there would be registration requirements under the sexual laws of the state of Texas that you must perform. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Sir,
Guilty.
are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
That's some stuff.
Are you pleading guilty on your own free will? Nobody forced you.
Yes, sir.
You're pleading because you are guilty of what this alleges you did in the indictment.
No.
You didn't do this.
You did do it. Right.
Yeah. Yes, sir.
What's your final answer?
Yes.
Yes. Okay. Did you just misunderstand?
Yes, sir.
Okay. I mean, you know what you've been charged with.
Yes, sir.
And I'm asking you,
Oh, yes, sir.
is this true, what it alleges?
Yes, sir.
Okay, in the indictment.
Yes, sir.
All right. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it?
Oh,
Discuss
yes,
it
sir.
with your attorney?
Yes,
Or
sir.
the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection is submitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made, correct?
Yes, sir.
You understand what you're charged with. You discussed this with your attorney. You were guilty of the crime charged and many lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objections, it's admitted.
Yeah.
Okay.
No objection.
Pre-sentence report, when?
We need to do a pre-sentence report, Your Honor.
It's a deferred.
Yes, this is a request of probation. They asked that we do a pre-sentence report on sexual assault cases.
For what purpose?
Because of the nature of the offense, Your Honor, and the complexity of it, and
What's the pre-sentence, what's the difference between, why don't we do a post-sentence report instead of a pre-sentence report? The quicker he gets on probation, isn't it the better idea?
Well, that's not my opinion, but it's up to you, Your Honor, what you say.
Okay, I think a post-sentence report is important because I want to know what the focus is, but.
In this segment, the defense argues for leniency by highlighting a history of harassment leading to the defendant's breaking point. Counsel frames her conduct as an isolated, emotional collapse rather than a pattern, stressing her relocation, parenting responsibilities, and continued education. The goal is clear: persuade the court that deferred adjudication will support rehabilitation while still allowing structured supervision. This portion establishes the human context surrounding the offense.
But I think that the general terms of probation that are normal and customary for this will be applicable. But if there are specific needs that need to be addressed, we can pick those up in a post-sentence report. Okay.
Yes, Your Honor.
Okay. State okay?
Yep.
All right. That's what we'll do when we do. Do you understand the situation here?
Yes,
And you pleaded guilty voluntarily, knowingly, intelligently, and because you are guilty.
sir.
All right. Anything else to add? I'm going to follow this agreement. You need a pen?
Yeah, I was right. Yeah, look. Hey, I'll take it.
If nothing further, I'm going to find you are pleading guilty today to the second-degree felony of indecency with a child voluntarily. No intelligent. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, we will come back after the post-sentence report is made so that we can review this report, all parties, and if there are any additions or changes that need to be made based upon the findings from the probation office, that will have to be included because we want to prevent or deter any further misconduct. Anything?
I just wanted to make sure that we're putting him on probation today, but doing what would amount to a pre-sentence report.
Yeah, we'll call it a post sentence because he's been sentenced today. But it would work just like a pre-sentence report. And if there's something that we need,
Okay, understood. That's something. What's the agree on?
what's going on? This is like the
Here,
most.
the defendant addresses the court personally, expressing remorse and describing fear during the confrontation. The judge challenges her account, noting that law enforcement found no evidence supporting her claim of being threatened with a vehicle. Her explanation reveals emotional overwhelm rather than clear self-defense. This moment shows the court weighing sincerity alongside the factual record, recognizing her remorse but questioning the justification she implies.
This is like the most important thing in your life, and you're looking around. What's going on,
People.
sir?
I was just looking at my people.
Is
This
relevant?
is the most important event in your life, sir.
Yes, sir.
I mean, you're looking at up to 20 years in prison.
Yes, sir.
You want to do some more public affairs, work, or you got to focus on the game here. This is the most important thing in your life, isn't it? 20 years in prison?
Yes, sir.
Okay. And also the victimization of a child. These are all serious things. You're not in a parade waving to the crowd. Yeah. Get your eye involved here. Come on. All right. Anything else, Dan?
That's it.
How long have you been in jail now?
January 30th.
Of this year?
Yes, sir.
It's about 6 months? 5 months?
Yes, sir.
How's that working out for you? Yeah, I wouldn't be happy with it. You're not enjoying yourself.
No, sir.
Can you imagine what 20 years in prison would be like? Are you focused now?
Yes, sir.
All right. Just have a seat over there and you'll see the probation office and we'll go over terms and conditions of probation.
Thank you all. You coach.
Okay. I'm looking at the indictments which allege first-degree felonies of sexual assault of a child. We're going to vote on attempted.
Yes, sir.
Isn't that 1 degree less?
Yes,
But these are third degrees. From a first degree to a third is not 1 degree less.
The agreement was to drop the first degree enhancement. There's an enhancement in the indictment.
What
Is it a
is
first? It alleges
The child being under the age of, I think, what is it?
no,
younger than 17?
it's the familiar relationship.
Oh, is it? Let me say that.
It alleges a familiar relationship.
I don't think.
It doesn't. Does not.
The judge pivots toward the seriousness of the offense, emphasizing multiple gunshot wounds and the potential 20-year sentence. He reminds her that provocation alone cannot justify using a firearm. Although acknowledging her clean record, he underscores the legal limits of self-defense. This section reinforces accountability. Even amid conflict, escalating to deadly force carries severe consequences that cannot be minimized by context or emotion.
I think it's just.
Yes, but he was just like, that makes sense.
Can I see the indictment, please, sir?
The
I
one?
don't have my file. Can I see your indictment? Yes, sir. There's an enhancement down here under this last paragraph here. It says has a familiar relationship or prohibited from having sex with because of that relationship. So we're abandoning that and just proceeding on the second degree and then dropping it down to a first degree.
What's that?
This that prohibited from having sex under 2502, I
The
believe.
discussion shifts to procedural accuracy, including correcting the PSI and recognizing the victim's strong opposition to probation. The prosecutor notes the victim's persistent communication with their office, underscoring her sense of injustice. The judge remarks on the absence of a victim's statement at sentencing, emphasizing its importance for an informed decision. This passage highlights the unresolved tension between the negotiated plea, the victim's expectations, and the court's responsibility to weigh all interests.
502, I believe, or something along those lines.
Oh,
That makes it a first
oh,
degree.
oh, oh.
So we're just
Okay,
abandoning
it
that.
doesn't,
We're abandoning that
it
language,
didn't
making it.
state it, it just referred to the statute.
Yes, sir. Then we're just making it
Okay.
a second degree and then reducing, doing an attempted. So I'm abandoning the language of the familiar part.
Okay. Well, there's no language that says that, but it just refers to the general
Yes, sir.
section of 2502.
Yes, sir.
With And this is 429. What are we going to do with 430?
Same thing, same exactly.
Okay, in each of these cases, does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
He does, and we may, Your Honor.
In summary, in cause numbers 23 CR 429 and 430, in summary, these indictments allege that on or about June 1st, 2020, in cause number 429, and on or about August 31st, 2020, in cause number 430, in Jefferson County, Texas, it is alleged you committed the first degree felonies of sexual assault of a child. Do you understand what you're charged with in each of these cases? Agreements have been reached in each of these cases. You would be pleading guilty to the lesser included offense of attempted
sexual assault of a child. Yes, sir.
sexual assault of a child. In each case, which would be third degree felonies in the way the case is indicted under section 2502, that would be dropped,
That is abandoned. Yes, sir.
abandoned by the parties. So the lesser included offense becomes a third degree felony of attempted sexual assault of a child under these circumstances, which means in each of these cases, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached. Whatever sentence shall not exceed, is that 3?
Yes, my handwriting. No.
Yeah, that's sort of. Whatever sentence shall not exceed a cap of 3 years in prison. So what we have here are the options, which would run concurrently with each other. So you're looking at no less than 2 nor more than 3 years confinement in prison.
That's correct. That's
Deferred or unadjudicated probation could be assessed. Is regular probation
I don't think
an
so.
option under these circumstances?
I don't know if it's an attempted. It might be.
It's involving a child less than 17.
10 cents usually, 3G as well, right?
Not necessarily.
Anyway, there's going to be a plea agreement, a pre-sentence report prepared. We will all come back, review it, make sure that it's true and accurate. Each party gets to sound in, and then the court will make its decision. Is that your understanding of what's going to happen?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
And again, how do you plead here for this lesser included, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Yep. Voluntarily, understand it, discuss it with your attorney, or the content's true and correct. State's Exhibit 1 is tendered into evidence and without objection is submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's free and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. And all of this is true. The state still help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report will be prepared to come back on
July 15th.
July 15th. Everybody will sound and the court will make its decision. Do you understand? Okay. That is all. Get a reset.
Yes, sir.